Good evening and welcome one and all to the special webinar session by Mediate Guru with Judge Srđan Šimac. Firstly, I will introduce Mediate Guru. Mediate Guru is a social initiative led by members across the globe. The aim of our organization is to bridge the gap between the general public and litigation. We are creating a social awareness campaign for showcasing mediation as the future. Having successfully conducted various international webinars promoting alternative dispute resolution, having a reach in more than 100 countries around the world, with an international family growing each day. We thrive to provide you the best lecture series through the best speakers around the globe so that you all can have a value addition today. I feel honored today to welcome our esteemed judge, Srđan Šimac. Sir is a judge and former president of the High Commercial Court of the Republic of Croatia. He is also a president of Croatian Mediation Association. Sir is also a mediation pioneer and one of the founders of Court Mediation. Sir is a mediator and mediation trainer and also lecturer, speaker, and mediation promoter nationally and internationally. Thank you so much everyone for joining us. Let us begin with our session. I would request our speaker to take the session forward and enlighten us all. Sir, please.
Hi, thank you very much for a nice introduction. Hello, everybody. It's my honor to being with you today and to share some of my knowledge and my experience. I'm sure that I wouldn't make mistake if I say to you, Happy Diwali. I am for a long time a judge, almost 30 years. I'm arbitrator, I'm a judge mediator, I'm a mediator and mediation trainer. So you can see or realize that I have approach to the law and the dispute resolution from many angles. And you will see, I see myself as a lawyer or a judge under evolution, and I am real proof that lawyer's mind can change positively. You will see how and why. So at some point I was a pretty formal and strict judge. I enjoyed in doing that my job in the way I knew, the only way, the traditional way, until the moment I realized that in spite of the fact I'm doing my job professionally, with the good quality, with the great reputation, at least half of my parties are not happy with me. Sometimes all of them are not happy. And I started to wondering what is happening with what we do or what will you do soon after you finish law school. There are a lot of triggers made me change myself and the way I'm doing things in law. One which was very funny, when my kids were so young and so little, people used to ask them, what your parents do for a living? And when I came in turn, they usually said, our father is a judge, but our mother is the law. So at that point, I realized that I'm not so important as I was thinking that I was. So you will see through my speech, I would like to remind you in advance that we as a profession, as a professionals, are not above the people. And you will see. So my tipping point in my profession was 2000 Canada, Montreal. It was the visit of Croatian judges. 15 of us came there to be introduced with the achievements of Canadian judiciary. And what came in front of me was amazing. Two subjects. One was how judges conduct in the courtroom. Nobody teach us about that in my life. And the second one was mediation, which is included in the topic of today's speech. So when I heard about mediation for the first time in my life, I literally fell down from my chair, and I realized there is something amazing, not just for the people in conflict, but for us, legal profession. Amazing thing. We need to make huge changes in a negative perception, public perception about us. So that moment, I've heard for the first time about mediation, and from the judge, it was my Diwali at that time. It was the festival of light for me, because it was enlightening moment and the beginning of changing myself as a person, as a human being, and as a professional. So, as you know, legal profession is one of the oldest professions in the world, and we call it helping profession. We are in a business of helping other people solving their problems. So, you know, even many lawyers, including me, thought or think right now that there are small and big problems for people. People always have a big problems. And no matter how it is complicated by the law or not. So the idea is people with a conflict act equally as the people with the pain. People with the pain need a quick relief as much as possible. But when we are coming to the part of our legal services, which is helping people to solve their conflicts and disputes, we are not helping too much, because our service is too long, too expensive, too uncertain, too out of their control. And actually, it is not a service at all. You know very well, as a young people, that today we are living in an economy on demand. Everybody, including us, want everything now, yesterday. So what kind of service are we offering if we are offering a dispute resolution system which needs 1, 3, 5, 10, 15 years of solving it? It's not service at all. So now we are living in 21st century. Everything has changed and is changing fastly, but you will see very soon legal profession and legal systems are changing very slowly, almost not at all. And now we are facing as a profession with the biggest adjustment in the history of legal profession. So we need to adapt. We need to be changed. So if we do not change, they will change us. There is an amazing expression, adapt or die. So I know, and I count on you, and legal profession count on you, that you will become a different kind of lawyers of new kind, lawyers of 21st century. So you and us, we need desperately and fastly to improve user experience with our services, because we will not be able too much longer offer the same way and expect different results. So the topic is justice. The justice is something very attractive for many, including non-lawyers. But on the other side, what does it mean? What does it mean, justice, for you? Can you remember what was among the first lessons you have heard in your law school, probably in first grade, in the first year of your school? You remember very much, and you felt as a huge impact on you. It was usually the justice and the law is not the same things. And it was kind of shock for me as a young lawyer. And I understand why it is so, but I could not accept anymore that we are here on this planet Earth just to offer the law and not the justice. Because if we stop to offer justice, we will stop with our services. Not so far from now. So the justice is pretty much exploded word without real meaning. Ministry of Justice, Court of Justice. But we as practitioners in law, we know very well that the justice and the truth are very rare animals at courts, because within the courts, within the litigation or arbitration, truth and justice are not important at all. Can you imagine that? Because we are not offering justice and truth, we are just offering the law. And someone said that the justice is reserved from the other world, not this life. So if you try to think about the justice, the word we like very much, and do not really think about its meaning, the justice is always subjective. All of us can own thoughts about what is justice for us. And there is almost impossible to secure or provide objective justice. If somebody of us can be a god, goddess, maybe we can do it. But even we judges are just ordinary humans. And we are not supermen, supergirls, and we are not the gods. And some of my colleagues forget that and act like a gods with a huge power over people. So I really believe, and it's not just my thought, that you cannot get justice from the third side, from the judge, from the court, from the state. Only justice you can get is from the other disputant in your conflict, in your dispute. But people are not finding a justice from them, they are asking and demanding justice from the court, but I cannot give you a justice. I can give you the law. And it cannot be a justice in the court, in litigation, if we are providing justice just for the one side. Justice and peace is two sides of the same coin. There is no justice without peace. There is no peace without justice. But in courtrooms, we are not even thinking about the peace. We are just thinking about solving the case. Finish the case. We are not solving life, business problems, conflicts. We are just solving legal problems. And the whole concept, even it is very important, judiciary in every society, and it will be there for a long time in the future. The whole concept of a confrontation, attacking each other in order to get something from the other side, is pretty wrong. Of course, sometimes you cannot force the other side, and sometimes you need the force of the state to convince other side or to force them to do something you need. But in most of the time, it is almost impossible to force someone to do something. Try in your ordinary life outside of the profession. Whenever you try to force someone to something, they resist. They resist aggressively. And it is the same with the court. And because of that, court decisions are rarely voluntarily executed. We need again force of the state to execute our court decisions. So try to think about for a moment, no matter you have experience with the courts or not, try to think about, so I'm talking today just about one part of our job, going to the court, litigation, fighting to each other, and try to think about the positions of parties in court, in litigation. I suppose that you never thought about that any legal suit is actually declaration of the war to the other side. Really, it's a legal battle, legal war, trying to conquer, to defeat, to make the victory over the other side. So many people think, many lawyers think, that the justice is, or that the justice is done when we defeat the other side by the force of the state. If you start to think about it, there is no satisfaction or happiness in any kind of victory over the other people except the victory in sport game. So, you know very well, if you decide to get or to take your client to the legal war, you have to know that no one gets out of the war in a better condition or in better shape than they were at the beginning of the war. It's the same with the real war, and it's pretty the same in a litigation war. All including are bleeding very much until the end and even after. So if we know that every war, including every litigation, will end by the peace, why we shouldn't start with the peace first? And you will see this is the one of the missions of the legal profession, not just to be gladiators, warriors, pit bulls, or other adjectives, but the idea for the new kind of legal professionals is to be not just problem solvers, but problem avoiders, prevention lawyers, healing profession, or peacemaking profession. And it's very possible. You will see, not all the time, but we need to practice that roles as much as possible if we want to stay in track as a profession. So, legal suit also means the highest level of betray in any kind of relationship. And can you imagine how our parties, our clients are feeling there? So in litigation, they are pretty invisible. They are passive observer. They are somewhere behind the scene. They are totally divided and cannot contact to each other. They do not understand us at a word. No one asks them anything relevant for them. Everything is out of their control. They are present in a pretty aggressive legal environment, full of blaming, confrontation, harming, huge length, expensive, risky, uncertain. And they feel totally helpless. And we think we are helping them, keeping them there, and trying to make a victory for them. You know, it's total nightmare for the people. And psychologists told us that legal environment, actually litigation environment, is among the hardest experience for the humans in their life. So I'm asking yourself, you start to think about what you can do from now on to make possible that people do not feel like that making business with us. So in litigation, voice of the people is not important. Only what is important is voice of us lawyers. Their side of the story is not important. Only what is important is what is legally relevant for us. And believe me, everything what is legally relevant for us is totally irrelevant for the people life and people businesses. You know, there is a kind of civilizational misunderstanding between legal profession and public and the people. They are asking from us to solve their life or business problems. And what we are doing, we are offering them to solve their legal problem. We translate life or business problem to the language of law, and after that they cannot understand anything. And the idea is start to solve their life and business problem and do not make their problems bigger when they enter to the courtroom. And believe me, I'm sure that you will not like to hear that. In the real world, there are no legal problems at all. Legal problems are invented by us, lawyers, and we live with them. So, a little bit more about justice. So, when we come to the court, to the courtroom, asking from the judge to decide instead of the parties, or we as a profession, as a legal professionalist, including me as a judge, we are falling in a professional trap, which is not exclusive right for our profession. What does it mean, professional trap? So, as lawyers, we used to offer our solution for the other people's problem. Can you imagine? We are offering our solution for other people's problem. So it doesn't work at all, because our mission, task, duty should be help them find own solution for own problems, because we don't know anything about their lives, businesses, and problems. And we are pretending that we know. Only what we know is the law. And the law is not enough to be a good lawyer anymore. So, whenever you experience a court decision, there are losers and winners. Usually, all included are losers, because even winner after the court decision stayed alone in the ruined relationship. Of course, it is not always like that, because there are many relations you don't care. But when you are close to someone, family member, friends, neighbors, co-owners, business partners, you are very close to each other, and court decision will ruin your relationship forever. So, the second problem with us, or with me as a judge, or with the legal professionals, is I, as a judge, my duty is to render the decision. When I render it, my case is closed, I'm happy, but I'm not living with the consequences of my decision, because my decision is go somewhere and make a huge impact on people's lives or businesses I don't see at all. And actually, and truly, I don't care. We should start to care as a profession about the people. So, you know, in the real life and even in litigation, actually there is a very rare situation when we provide a real justice. When somebody misused the law and then we punish them by the court decision. But usually it's very rare, and it's so, and there is no actually the case in which the one side is totally right and the other side is totally wrong. but I have to decide who is right and who is wrong, and I'm doing that all my life. But hopefully, and I'm fortunate that I'm not doing just that. And we will talk soon about what can we do more. So I would like that you start to think from now and ask yourself, before you enter to the profession, try to think about who is the real owner of the conflict, of the dispute. The real owners are those who created them, not we as a profession. Start to think about who is the only expert for their lives. We are not experts for our clients' lives and businesses. They are the only and the best access for their lives and businesses, but we usually excluded them from their disputes and their conflicts, and they put them out of control of what is going on. And if you exclude disputants from the important part of the litigation, you cannot provide them anything than force and justice made by law, not by their needs. So the disputants are the only ones who knows what was happening among them. They know the best solution, which the solution is the best for them. They have only authority to decide about themselves. But somehow, in doing our profession, our work, we alienated them from the only thing they really care about, their destiny, about their life, about their businesses. And when you enter with your client to the courtroom, you are actually accept that you are lose your will to control what is going to happen. So how can we give much more control to the clients, to the parties, over their disputes and over their conflicts? So what can we do? What we can change? So there is an amazing procedure I mentioned at the beginning called mediation. Mediation is not here to replace the courts and the legal profession. Mediation is not even alternative of litigation. Mediation is just alternative of failed negotiation. When negotiation failed, that's the right time for the mediator and mediation, because 50% of negotiations failed. Can you imagine? And after that, people think that everything has done what it was possible, and they decide to go to the litigation. It's not right time for the litigation, because litigation is the beginning of true war between them and make them incapable to solve their problems by themselves anymore. Whenever you put them in litigation, you took over their power to create or be involved in the solution they need. So, why it is possible to find a justice in mediation? why it is the highest form of justice from my own experience. You know, mediation has no magic wand and solve all the problems in all over the world, but it can help a lot to a lot of people, to a lot of disputants in a way you cannot even imagine right now. So, why it is so possible? Because mediation procedure is the only procedure in which you can come with the problem and get out with the solution. No matter you think about court decision is very often is not a solution of the problem at all, because problem is still there. Mediation is a procedure in which you rely not on third person as a stranger, but on a third trusted person to whom you trust, to whom you choose to help you find a way out of the conflict, and who care equally about all sides and not offering them own solution for their problem, but offering a help them to find their own solution for their problems, life or a business. In mediation, parties are the most important persons, and they feel they're empowered, recognized, respected, heard. In mediation, disputant voice matters. Everything what is important for the disputant in mediation, he or she has right to tell in front of the mediator and in front of the other side. Because in mediation is not important what is legally relevant, but what is relevant for the disputants. All of us have something to say, and we are eager to have possibility to say what is important for us. In litigation, people don't have such an opportunity, but in mediation, everything is created in order to people can start with the communication which was broken, which was failed, and they don't know how to proceed, but now we are helping that to communicate again, to listen each other without interrupting, without fear that somebody will decide about them as a judge in the courtroom, because mediators are not people who are going to decide about disputes. The real owners of their disputes and their solutions are disputants in mediation, and that's totally different approach in comparison with what we are traditionally doing at courts. You know, in mediation, disputants are not enemies. Disputants are collaborators in finding the way out of the conflict. So we always start mediations with the words like this. From now on, we are begging you to change your approach. Otherwise, you wouldn't be here. What does it mean? What I think of, what I am really think. It is right time to start to not to attack each other, because it is totally counterproductive. It is the right time that you together start to attack your common problem. So instead of attack to each other, let's start now to attack together common problem and find common solution in which both of you will find interest, in which there will be no winners and no losers, and in which you are not going to lose your face and you will not be defeated. Because the only solution of any dispute is not a victory, but a solution. But the solution which is tailored to the needs of the disputants. Because what they need, it matters in mediation. It doesn't matter at all in litigation what they need. We think that they need the law. They don't need the law. They need the solution with which they can feel a peace inside of them, and with which they can continue with their lives and their businesses. So, in mediation, disputants are not enemies. They are partners. They are partners in solving their own problems. It's totally different approach, and believe me, it works most of the time. Not always, but most of the time. In mediation, disputants and their lawyers, who have amazingly important roles in mediation. I didn't have almost none mediations without lawyers in it. So you and your client in mediations have total control over the process, over the outcome. In litigation, you cannot guarantee to your client anything, but in mediation, you can guarantee that they will be satisfied with the procedure, and they will feel good with themselves, with the other side, and with a new way of understanding the conflict. In mediation, everything is confidential and free of any restrictions in exchanging information. Can you imagine that? In courtroom, people do not tell truth. They tell half a truth. They hide the truth. But in mediation, we are motivating them to reveal whole truth, because without enough information, which are divided on both sides, it's not possible to find a great solution. Actually, it's not possible at all. But when they start to freely exchange all information they have, because in front of them it is not a judge who will decide about the case. It was the beginning of cooperation and the beginning of changing the way you feel about your righteous, or about feeling I am right in this case. Because with the new information you realized that you are not so right as you thought before. And it is beginning of exchanging two different perspectives and truths, and trying to find the third one, which is common truth and which is accepted for both sides or many sides. So in that way, disputants in mediations create own personal tailored solution, because they were involved totally and actively in creating it. It is their solution, and they feel, because of that, they feel it is just, it is true justice. And if they find own solution, they execute it voluntarily. There is no need for appeal, for a Supreme Court, for a Constitutional Court, or other courts. It is the end of the disputes and the beginning of the peace between them or among them. So in mediation, all disputants feel themselves as winners. They are happy, they continue with their lives, they make a harmony among themselves, and they learn how to deal with the other side again when any kind of conflict arises. You know, when ADR, alarming drop of revenues, ADR came to the United States, lawyers declared ADR, alternative dispute resolution, as alarming drop of revenues. But today, what do you think? What they use as a slogan today? Today they use happy clients pay their bills. So please, this is the right time. Actually, the right time was yesterday to start to work for the happy and satisfied clients, not for unhappy and dissatisfied ones. You know, and you will see it's not bad to earn money for your services, but it's bad from my point of view. I'm not here to judge, but I would like to share my experience. When I earn money and help the client simultaneously, I'm happy. If I earn just money but not help, I'm not happy. And my client will not be happy, and he will not be back to me again. So, few conclusion remarks. So, try to think about in the future, very close future, that legal advice is not a right. When people get legal advice from us, they think that is their right, but it's only our opinion, and every lawyer have different opinion. You know. The other side, the other thing, people, including lawyers, confused a lot good legal solution with a good solution for the parties. So please try to remember these words. Very often, good legal solution is not a good solution for the parties. And your task tomorrow is to offer all kind of information to the parties. What does it mean to go to negotiations, mediation, litigation, arbitration, and other forms of legal dispute systems that you can decide together with, and that the parties, clients can make informed decision which procedure is the best for them. And we don't need justice anymore in the sake of justice, but we need a justice for the people and their needs, in the interest of people, not in the interest of justice, because there is no justice without people. So, resist, please. Very soon you will become lawyers. It's a very distinguished profession. And it depends very much what you will do with it. Please, you will be in a huge challenge and jeopardy to feel very important, like I was wrongfully. So resist, please, the feeling of being superior about anybody. You are not superior. maybe you will know the law better than the others, but you are not superior or above them in any sense. Resist to wear all the time professional mask. You will see it is so huge temptation to wear professional masks when we enter to the court and the courtroom and when we are talking with the clients. Try to put off your professional mask as much as possible and be authentic you, human. Try to always be human being first and then professional, and try to adopt the rule which is very important for me. When you are going to face with other people, remember, no matter they are clients, your clients or not, you will always be faced with the amazingly different, unique, worthwhile, and equal human being, and treat them the same, equally, with respect, and try in your practice, when you are defending the interests of your client, do it without harming the other side. And to tell you from the real example, what is the difference between mediation and the courtroom, and how we can be closer to the justice even in the courtroom, I will tell you a short story from the courtroom, and after that we will see one slide about the change. So try to imagine, please, that we are in the courtroom. You can imagine me there as a judge. Try to imagine that in front of me on the different sides are lady and gentleman who are parents of his minor child. They are in a divorce and they are fighting over the custody over his son, who is 7 years old. There were lawyers with them on both sides, and they are arguing, yelling to each other, harm each other with words, try to accuse each other that they are not capable to be a parent. And it's very rare, it's very often occasion in the courtrooms. And at some point they lost the control, yelling to each other, and made some kind of mess in the courtroom. And the judge, let's say me, I lost my temper at some point when when everything went out of the control, and at some point I banged on the bench and said, "Stop talking anymore." So they looked at me surprised and calm, lawyers and the disputants, and I said, "You step over and you are totally out of control with your manners. Before we continue, I would like to ask both of you one question. I start with the mother. Lady, I'm very curious. Do you love your child as a mother?" And she said to me, "Judge, what kind of question is? Of course, I adore my son." "Okay," I said. Now I go over to the father and ask him, Mr. John, I don't know. I would like to know, do you love your child, your son? And he said, of course, Judge, I would give my life for my son. Okay? After that, I said to them, you as a mother and you as a father, you love your child tremendously. And I don't love him at all. And I cannot understand why you put the destiny of your child in my hands. So it was an enlightening moment for both of them. They looked to each other and their lawyers, and they asked to go out of the courtroom. And they came back after half an hour. And I made the decision like they want, not like I want. I made decision which is suitable and tailored to their needs. And that's the point. And try to do it whenever it's possible. So please, this is just one part of what we can do as lawyers. There are many others, especially when we start to talk about new technology in law. So far, let's finish with the slide about change. Please, can you share with all of us this cartoon picture or drawing? So definitely we have tools to use to improve ourselves, to improve our services, and to improve our relation with our clients. It's hard to appear, huh? Okay, stop running with it. Never mind. Let's start to use what is available for us to make our profession great or greater. And we as experienced professionals, legal professionals, we believe in you that you will do what all of us and our societies need. Thank you very much. Please, I wish very much to hear your questions.
So let us begin with the questions. The first question is, what is the impact of European Union law in Croatia?
So Croatia is a part of European Union. So every legislation which is part of the European Union is a part of Croatian law. So it's a great impact. So in a way, we are the same country, consist of the many countries. We have some part of the law together, and we have some part of national laws. And usually they cannot compete to each other. Any else?
Thank you so much for the answer. The next question is, would mediation, in your view, need to be hybrid, like med-arb, etc.?
So it's kind of become popular, med-arb or arb-med. Some people need to start with the legal suit in court or in arbitration. Sometimes it means I am serious, because the other side wants to talk at all. But when they start litigation or arbitration, it's harder because they are entrenched in the positions, legal positions, and they started with the war, it's much harder to making peace, but it's not impossible. If you find proper lawyers and proper judge or arbitrator, they can easily, with your help, transfer arbitration or litigation to mediation or send you to use the mediation. So mediation is fine in every stage of dispute resolution, but general idea is try to use it as early as possible. Maybe you can stop sharing this these drawings. Okay. Another one, please.
Thank you so much for the answer. The next question is, for a commercial ADR, would parties be less likely to suffer a blow as such?
Can you repeat me this question? I didn't understand.
Sure, sir. For a commercial ADR, would parties be less likely to suffer a blow?
It's kind of impression that commercial cases are more suitable for mediation. And because they are not really tied or bonded with the case, because it's not their case, but their company case. But usually it's not a real truth. Why? Because there is no, in reality, there is no, or there are no conflicts between companies. Companies do not exist. They exist just on paper. There are always conflicts between people in the companies. So even there are much more emotions for the people who are not represent their companies, but themselves. Even in commercial cases, mediation is can be very emotional, and actually it's amazing because in mediation disputants in disputes among companies, in mediation people are talking about their economic interest, not about legal interest. And when we come to their real interest, the solution is very close. When we start fighting about the law, which is not the essence of the dispute. Okay?
The next question is, does this apply for divorce proceedings that all parties bleed hard?
Yes. All kind of family disputes, and including divorce cases, are born to be mediated because people who were close for years are imprisoned in a huge conflict, legal battle, legal war, which is created by us lawyers, and nobody deserved such a suffering. And you had the opportunity to realize from my short story from the courtroom how it is in a very simple way convert the minds of the disputants to try to think differently about each other, about the conflict, about the solution, because the idea of mediation is to give back responsibility for the dispute and for its solution to their creators, not to take responsibility for ourselves like we do. So when they address to us for the help, it doesn't mean putting your clients aside and started to dealing with the dispute without them. It's a contrary. We have to work together with them and to actively involve them in finding their solution, which is the best for them, not for us. Thank you for the question.
Thank you for the answer. The next question is, can we solve every legal problem through mediation?
Actually, we can. It's so hard to imagine which case would be not suitable. Usually, we are not. It's very rare case that we are dealing with some criminal cases in mediation. Even we are doing even that when there is some kind of damage, compensation of damage. It is not. It is not possible to mediate some cases which is important for whole society if they need some precedent for all society and they need the court decision. And it's much harder for state authorities or local authorities to go to the mediation because they are fear of taking responsibility for settlements. But things are going to change and they are changing. And even from recently, I am going to be a mediator between state of Croatia and one foreign investment. And the state is so keen to solve the problem without arbitration, which is, how to say, crazy expensive. And from my point of view, not necessary. Even it can be lucrative for our profession. More, please.
Thank you so much, sir. That brings us to the end of this session. Thank you so much, sir, for such a vibrant, interactive, and knowledgeable session. I'm sure our participants learned a lot from our today. I would also like to thank all the participants for joining us, and I would request everyone to fill up the feedback form before you leave in order to receive your certificates. Thank you so much, sir, for joining.
Thank you very much to all of you. Enjoy in your life, in your profession, and be everything you wish to be. Bye to everybody.
Bye, sir. Thank you. Participants, before leaving, a special announcement for you all. Mediate Guru has officially launched the second edition of the landmark Virtual International Mediation Competition 2022. Register your spot with the winners right now. Registrations are open now. Also, Mediate Guru's mediation schools registration are also open for enrollment. Learn about mediation from global experts. Thank you everyone for joining us. If you don't want to miss any updates from Mediate Guru, follow us on our social media handles and also join the WhatsApp update group sent in the chat box. Stay healthy, stay safe. See you all very soon. Bye.